Hello and welcome to this week's Fact Friday. You will see that I'm again joined by Katherine Morgan from our commercial property team. Katherine, it's great to have you back on Fact Friday. We have 3 questions for you today, but before we move to the questions, are there any updates from our last Fact Friday we need to be aware of?
Hi, Michael. So everyone has been released this week to a certain extent, which is going to mean different things for different people. So some businesses have gone back to fully office-based working. Some people remain working at home, and some businesses are now considering a kind of blended approach. And being able to eat and drink outside now is hopefully going to be a lifeline for the hospitality industry. Despite months of lockdown, the commercial property market, as the same as the residential property market, we've been very busy with new acquisitions, new leases, not just disposals, which is a really positive sign. And we are continuing to see a spike in activity with tenants seeking warehouse premises and industrial space. So it's all looking quite positive.
Excellent. Which brings me on to our first question for you today, Katherine. Are there any particular legal updates that we need to be aware of?
We spoke a few weeks ago on Fact Friday about the government introducing a code to encourage transparency and flexibility between landlords and tenants. Since then, it's been endorsed by some quite heavy hitters in the property industry, such as CREPSI, the British Property Federation, the Registered Industry of Chartered Surveyors, British Beer and Pubs Association, and Agricultural Law Association. There's lots of others, but I'm not going to reel them all off. The issue now is that the stay on a landlord bringing forfeiture proceedings is still running until the 30th of June this year. But there's going to be thousands of tenants who've not been able to open in lockdown, and many of whom are going to be in arrears of rent, whether that's been agreed with the landlord or simply they just couldn't pay.
Excellent, thank you. And on to our second question today for you, Katherine, is how is the government hoping to resolve this?
So, in relation to the code, they've updated it. But before I get on to that, they have called for a consultation on COVID-19 and rent arrears, and it's been called a call for evidence. So if I just read out a little bit of what they've published on their website. So it's intended to support the government's decision making on the best way to withdraw or replace these measures, which is referring to forfeiture, while preserving tenant businesses and the millions of jobs that they support. And it's carrying on trying to encourage negotiations and to keep tenant businesses afloat rather than there being a flood of forfeiture claims by landlords. Just reading some of their wording in relation to the government's objective, they want to gather more evidence in this consultation to understand how landlords and tenants are responding to the build-up of rent arrears that has occurred as a result of businesses being unable to trade normally during the pandemic. They basically want to understand the risk to economic recovery posed by remaining rent debts and to understand how the parties are adjusting existing lease terms to deal with this. That's their objective. They're encouraging all businesses and both landlords and tenants to contribute to the consultation. They particularly want to hear from small to medium businesses to assist them in what they're going to publish and how they're going to decide we go forward. And then the code itself, last week they produced an annexure to the code which specifically relates to rent arrears and service charges accrued during lockdown, so those two forms of debt. It's a template document. It's quite short. I've had a read through of it. That's a template for landlords and tenants to use in discussions about rent, the arrears, and ongoing lease terms. It's a really practical document written in plain English that everyone's going to be able to understand. And it just gives advice to both parties on what they should and they shouldn't do, such as what evidence the landlord can request from the tenant, what it can't, what it's reasonable to do and to ask for. There's also some links to the court's requirements before litigation can be commenced. And that is going to be really helpful for parties who they just can't afford legal advice and they need some straightforward early advice to know what they want to do. I think it's a good document and starting point for the parties to see what lies ahead, and it's available from the government website.
Excellent. Thank you very much. And our third and final question for you today, Catherine, which is what is the message you want to send out to both landlords and tenants?
The message really is, although it's the cut-off is 30th of June for the land where the landlord can't bring forfeiture proceedings, you need to start discussions now, whatever side you're on. I would have a read through the code. It's only a page and a half long, um, but it is safer to seek legal advice. You basically want to ensure that the opposite party is proceeding in a fair and ultimately legal way. And a good solicitor will be able to help you negotiate new terms and to help you structure a way forward, whether that's a variation of the lease or a new arrangement, whether you are the landlord or the tenant.
Excellent. Thank you very much, Catherine. If anyone has any questions, please do pop them in the comments section below or get in touch directly with myself or Katherine Morgan. Catherine, it's great to have you on Facts Friday. And for everybody else, see you soon. Take care.
Thanks, Michael. Thanks.